Hi, this is Cora Stack here, Dr. Stack. I just wanted to talk here about something that I feel is very important with regard to constitutional law, and it was something that I observed uh, as a matter of trying to understand why I ended up in a particular place on the eve of the presidential election in Ireland, in October in 2025, and I was in a trap. And I was thinking, how did I get into this trap? And who set it for me? That's the question. Anybody has an answer for that? I would love to know. So the constitutional blind spot, my Irish Supreme Court challenge, why it matters, inverted commas, globally. In this video, I want to explain in very simple terms the significance of my recent papers on constitutional democracy together with Miss Maureen Kenny, but also the constitutional blind spot, constitutional coherence, constitutional maintenance, and constitutional continuity. And I call this collection of papers, inverted commas, the calculus of constitutional law. Being a mathematician, that's the word I have for it. These papers arose from my own Supreme Court challenge in Ireland concerning the 2025 presidential nomination process. And in a million years, I never thought I would be looking at constitutional law and that I would be uncovering these blind spots and looking at these concepts and trying to figure out, a real problem with constitutional law, and not just in Ireland, but globally when it comes to elections in particular. So my case has been adjourned, as maybe viewers know, pending the adjudication of a related test case taken by Mr. Niall James Byrne. That case concerns the constitutionality of the presidential nomination process, including the role of political party control over local authority nominations. This is a huge question for the Irish Supreme Court. No question, in my opinion. It's all about a closed system. If a system becomes closed, I think there's a huge onus on the Supreme Court to look at that and to see, has that, is the boundary, has that gone too far? So that's all the design of Article 12, and the people that are tasked with looking after Article 12 on behalf of the citizens of Ireland are the Supreme Court in particular. So they've got their work cut out for them, definitely here. But it's a huge challenge, a very interesting case, I think, because of this issue. There's a global aspect to this case, which perhaps, I've highlighted in my research. But my own work has gone further. While researching the sequence of events that led to my case being reserved with judgment until the day before the presidential election, I began to see a much wider constitutional problem. Now, this would never have happened had case management not put me in this position where the courts or the papers were saying that my case was, in inverted commas, entirely baseless. So this is not just about one election. This is about one candidate. These papers are not entirely baseless. In fact, I would challenge the press to challenge them on this issue. Can they say that these papers are entirely baseless? And if they can, well, they're smarter than me, and I'd like to know who that person is. So I'm not being not being pejorative in any way, but it's not just about one litigant. This is how I saw it. It was about, after months and months. Now, this wasn't an overnight insight. This was deep work over many, many months to try and get to this point. So it was like doing a PhD in law in a very short time. So it was incredibly hard work. I mean, my brain is still trying to recover from all this research. It's about how a constitutional democracy can fail silently, even while everyone appears to be following lawful procedure. This is what I call the constitutional blind spot. So a constitutional blind spot is a place where the Constitution appears to provide a safeguard, a route, or a remedy, but in practice, there's no effective way to enforce it in time. And that, I don't think I'd have had that insight had it not been put by, inverted commas, case managers right at a point where this was not possible. So perhaps it was the test by case management. Were they trying to make a right fool out of me, or were they trying to, get me to figure it all out? That question, it remains unanswered. So I don't know who's doing the case management, but perhaps there was I think I said something, I was going to challenge the courts, and perhaps maybe the courts might say, oh, you test this lady out, or see how smart she is. So in simple terms, the Constitution may promise something, but the legal system may not give a real answer before the moment has passed. This is especially dangerous in election cases. Elections move quickly. Deadlines are fixed. Once an election takes place, the courts may be reluctant to interfere. This this is a global issue with elections. So but before the election, the courts may also be reluctant to interfere because the matter is seen as political, urgent, disruptive, or not yet fully crystallized. So the citizen, particularly if it's a litigant person, they'd say, well, that person doesn't really know anything, and they're kind of off their head if they're challenging. So the citizen can be tracked. So that was caught on a trap. That's a brilliant song by the wonderful Mr. Elvis Presley. Can't look back. Well, let's see what I did. Before the election, I did look back, and that's why I got all these brilliant papers. Before the election, the court may say it is too early. During the election, the court may say it's too risky. After the election, the court may say it's too late. And the result is this: too early, too risky, too late, and no constitutional review at all possible. That is the constitutional blind spot. Now, when I mean by constitutional review, I mean constitutional review in time. This is the key insight behind my recent work. In a constitutional democracy, it is not enough to say there was an election. It is not enough to say there were courts. It is not enough to say there were procedures. The deeper question is this: did the constitution's safeguards actually work? Whether I was a citizen or a mathematician or whatever I was, these questions would apply to anybody that was put into this position. Could the citizen realistically challenge the process? Certainly not at the time that my judgment was reserved until. Could the courts provide an answer in time? Could the Constitution be enforced before the democratic event became irreversible, as it did once the election by Article 12? So if the answer is no, then democracy or constitutional democracy may only be formal, not substantive. So formal democracy means that the structures appear to exist. Substantial constitutional democracy means that these structures actually protect the people. My work argues that constitutional democracy depends not only on the words of the Constitution, but more importantly on the functioning of the whole system. This leads to the second idea, constitutional coherence. Constitutional coherence means that the Constitution must make sense as a whole. The different parts must work together. If the Constitution provides a nomination route for presidential candidates through local authorities, then that route must be real. It must not exist only on paper. If political party control, delay, cost, procedure reframe or institutional caution makes that route impossible to use in practice, then the constitutional system loses coherence. The machinery may still be there, the words may still be there, the offices may still be there, but the constitution function has failed. This is a very serious problem for Ireland, but it is also a serious problem for constitutional democracies everywhere. So this is where the global dimension comes in, which is absolutely mind-blowing that this insight has led to this global dimension. Many democracies today are under pressure, as we see all around the world. Sometimes that pressure is obvious. Sometimes it comes from authoritarian leaders, emergency laws, attacks on the courts, or manipulation of elections. But sometimes the pressure is much quieter. It comes through delay. It comes through legal cost. It comes through procedural complexity. It can come through judicial restraint. It can come through doctrines such as mootness,